All of you are amply aware at how international Singapore actually is as a financial center. Singapore has considerably grown as a financial center globally over the past few years, and there are a good number of international banks in Singapore. You have 121 foreign banks here. You can see the split up yourself. And on top of those 121, you would actually also have 37 representative offices also of foreign banks. This becomes even more impressive when you compare it with 6 local registered banks. But that is not the only importance of international business in Singapore for banks. The more important side of it for all of you, I'm sure, is actually assets under management in Singapore. For the end of 2013, that's the last fully reported numbers I found, there are 1.82 trillion Sing dollars assets under management in Singapore. 77% of these 1.8 trillion are actually from abroad. So Singapore's financial market is substantially based on international business. Of the 77%, there is approximately 56 sourced from Asia Pacific, 21 from Europe, and 10 from the US. The question then is, how do you actually deal with all these international clients? There is Singapore regulation, for sure, it applies to all of you, to all of us. At the same time, when you are dealing with international clients, you also enter the realm of jurisdiction of that client. So what does make an activity, a financial activity, a cross-border activity? It's actually quite simple when you have more than one jurisdiction involved. And that can take a very, very broad scope, depending on the activities you look at in the daily business of your relationship manager. It is about prospecting for a client. That client is potentially a foreign client. You may meet him abroad. You may send an email abroad. A foreign client, for example, your Indonesian client, is coming to Singapore to visit you. So there are, on top of the prospecting, you then have the entire relationship with that client. If your Indonesian client goes back to Indonesia, you somehow want to service him. And you want to sell products to him. All of these aspects have cross-border issues connected to it. There are also different ways of how those cross-border activities can actually take place. An important distinction is between active and passive activities. The active activity is when you as a bank approach the client for something, versus the passive, when the client approaches you to perform an activity for him. For example, the client comes to your bank and asks to open a bank account, versus you go out and ask a person if they wouldn't be interested in opening a bank account with you. The passive cross-border activity is often also referred to as reverse solicitation. That just as a term, because I might bring it up again throughout the presentation. Then your cross-border activities can also be direct or indirect. Direct examples are your relationship manager, so the representative of your bank directly interacts with the client. It is also very well possible that you have an indirect activity. For example, you have introducers. The introducer obviously introduces that client to you. So does that introducer work for you? How does that fit in when that introducer is, for example, based in France, but you're a bank registered and licensed in Singapore. Same thing when you work with independent asset managers who actually take care of most of your interaction with the client, but the account is booked with your bank. Well, yes, that independent asset manager will be your indirect link to your client. In cross-border activities, there are certain common criteria when regulation becomes applicable to the activity performed in a country, so that your activity become subject to a specific regulation. The most common criteria are territorial, personal, or then mixes of it. Territorial criterion is when you, as a bank, go out into a different jurisdiction. For Singapore, that is, there is one challenge already mitigated. For example, in Dubai, you would also have to differentiate in jurisdictions between the financial center and regular Dubai, because it's two different jurisdictions. Singapore only knows one jurisdiction on its shores. But it is about touching the territory of that other jurisdiction. It can be that you physically go there, but in many cases it is also when you simply have your activity directed at that jurisdiction. So if you send out an email advertising campaign, for example, targeting Malaysia, you may very well be caught under a territorial criteria, and your activity may be regulated by Malaysia as well. The other most common criteria is personal, which means you interact with a person who is most commonly a resident of that other jurisdiction. We have heard today examples about your American citizens. That is the other one. You have a citizenship that can actually bring the jurisdiction with it. But most often it is about residence. So you have your client from the Philippines. He may actually bring some of the regulation because he's usually living in the Philippines, even to Singapore. Then you have the mixes in between territorial and residence. Some countries only apply their regulation when you actually act on their territory or aiming at their territory to a resident of that specific jurisdiction. But if you are on their territory interacting with a person who does not reside in that country, you're free to do it. And then you have some special ones that differentiate their criteria according to the specific service you actually provide. For example, in Hungary, there are special criteria for credit activities, or more prominent example, in the US, you have a personal criterion that applies on banking activities, whereas most other things remain on a territorial criteria. For when you have the attraction that you are becoming subject to that foreign regulations, or most regulations, also have common thresholds when it applies or when safe harbors apply. In particular, safe harbors can be of significant interest to you, because that would mean that despite you performing a generically regulated activity, in that specific case, you are not regulated and thus allowed to perform that activity without license. Common thresholds and safe harbors are what I indicated among the different types of cross-border activities already. Reverse solicitation, the passive interaction with your client when your client searches you for your services. It can be about the intensity of your activity. For example, some countries apply thresholds of if you perform an activity for no more than 20 clients, it is unregulated. Starting from your 21st client, you will actually be regulated. It can be about establishing a branch or subsidiary, an entity on the shore of that specific jurisdiction, or it can be about the client status. In Singapore, we know very well the difference between your retail client, your accredited investor, your institutional investor. So in several countries there are differences. Do you need to be regulated if you interact with different types of clients? The risks you run in your cross-border activities are actually multifaceted. The first one I already touched on, the regulatory risk. When you go to a country, to a jurisdiction, you're expected to have a license if you are performing a regulated activity. We all know it from Singapore. You want to be a bank, to perform banking activities in Singapore, you better get your banking license. Don't expect any other country to be any different. You go to Pakistan and you want to perform banking activities, they have the same thing. They ask you to have a banking license. So you have your regulatory exposure, be that banking, be that financial advisory, be that fund management. That depends on the specific country, what licenses they have, what activities are licensed. The next one is that you also have a legal risk from a private law aspect, because in some countries, I will get into examples later on in the presentation, you have an application of forum, a choice of forum because of consumer law. You have a client in that country, and purely because he is considered a consumer, he can actually take you to court in his home country, independent of your agreement. That consumer law can overrule your choice of forum in your general terms and conditions. The same thing applies for applicable law. Many of you probably have an applicable law clause in your general terms and conditions. Consumer law can overrule that. So your French client who is actually banking with you in Singapore may decide to sue you under French law in France. And you can't help it. The only challenge that he may find is how to ultimately enforce it, but I would expect a French court decision to also be enforced in Singapore. The next one, also a legal risk, is actually criminal law. On the one hand, that comes straight from the regulatory law. You perform a regulated activity without the necessary license. You most likely are also committing an offense. There will be some fine with it. But at the same time, for example, when you look at foreign exchange controls, it can mean, or also tax evasion, it can mean that the foreign authorities consider these to be aiding the client in violating their laws. So you are all of a sudden criminally liable as an accomplice in the criminal act of your client. And a third one, or the fourth one, is tax, and that is now not primarily the tax that your client has to pay that he may be evading, as is commonly discussed under AML, but it is most of all about the tax issues on you, your bank, your representative traveling to that country. It is obvious when you establish a subsidiary abroad, yes, that subsidiary will be locally liable for taxes. But in many countries, if not most of all, if you stay in that country for a too extensive period of time or have revenues above a certain threshold that you generate in that country, you may become liable for taxes in that specific country. So if you have your relationship manager for a month at a time in the other country, that relationship manager himself and potentially your bank may become liable to taxes in that foreign country. And a final point is foreign exchange controls. Many countries actually have foreign exchange controls. Well, still more don't have it, but the list is quite long. For example, India, China, Malaysia, Thailand, South Africa, Ukraine, Senegal, Venezuela, and surprisingly also the Bahamas. So whenever you do anything with a client from there, you should actually consider whether that client can ultimately bring his asset from his home country to Singapore. So having gone through all that theory and those threats from cross-border financial activities, let us look at some ways of how they are being executed. The most simple one is probably when your client comes to Singapore, you meet with your client in Singapore. So you have all the issues applying of your Singapore license. Don't step beyond the boundaries of your Singapore license, but that is the same even when you are dealing with a Singapore client. What you should, however, not completely forget when you are dealing with a foreign client, even in Singapore, when you meet with him in the meeting room of your bank, is where you have that personal criterion that client may actually bring some regulation with him simply because he is a resident of another country, simply because he is a citizen of another country. For example, for Canada and the US, investment activities with a resident of those two countries will always be regulated by US or Canadian law. Another quite simple example of cross-border activities is the presence in a host country. You set up a branch or subsidiary in a different country, it becomes quite evident that in the other country you also need to have a license. Your branch or subsidiary needs to be licensed for your specific activities. If you stay within the bounds of that license, you shouldn't have too much trouble. Same thing as I mentioned before about visiting a client visiting you in Singapore will also apply here. If you have that client, a client from a different country than where your branch office is situated, visiting that branch office, he may once again bring his home country regulations along. Another very important point to remember when you are setting up or dealing with branch offices and subsidiaries is the principle of segregation, which applies in most jurisdictions. That means your subsidiary can actually not promote your services of the Singapore head office. So, for example, your French subsidiary cannot simply drive clients to Singapore because of French law, possibly. If you simply establish a branch office, that risk is slightly mitigated because you are at least considered to be the same legal entity. Now, the regulatory challenges skyrocket actually. As soon as you have your relationship manager visiting a client in another country, it becomes a lot more difficult. Because by visiting that other country, he basically exposes himself and the bank to the regulations of that specific jurisdiction. So you again have to think and consider what activities can be performed in that country. But because you don't have a branch, your head office isn't there, that means you are restricted to activities that are not regulated in that specific country. And what exactly is regulated in a specific country varies. You need to look into the specific jurisdiction. As an example, for Japan, you may present the bank through general terms, through objective information without any solicitation of your services, actually. As soon as you want to describe banking services, services connected to banking services, describe money lending services, investment advisory services, asset management services, or brokerage services, you are entering regulated territory. You cannot make any of those descriptions in Japan without a license. Only Japan licensed financial institutions must do that. Similar thing also applies in the Philippines. As soon as you become active on the Philippines, be that to provide investment advice or even to accept brokerage advice. Let's say you are a relationship manager visiting the Philippines and so handily that client passes on a brokerage or buy or sell these or those shares. That is actually an illegal activity for you in the Philippines. In some jurisdictions, as already indicated, there is a difference depending on the status of your client, of your investor. For example, in the UK, several activities are limited to providing them to knowledgeable clients. Then you can perform them without the local license. Your same activity to other clients, you would not be allowed to perform. And at the same time, when you are visiting the other country, in many cases, local private law will also apply. So, for example, the Lugano Convention, which is a treaty on the application of different laws, which jurisdiction applies, and the Lugano Convention is signed by all of the EU member countries and some other countries on top of it. The Lugano Convention, or the local regulation of the country you are visiting, becomes applicable when you perform the service in that country or are targeting a client in that country, and the client is considered a consumer. Immediately from that, for example, you're visiting your Italian client, Italian law is applicable, and you will have a forum in Italy. So if your investments that you made for your Italian client go down the drain, he can sue you under Italian law in Italy. The perspectives of that may not be pleasant for everybody. Another challenge is actually whether a contractual agreement will be valid or not. In some countries, a contractual agreement is only valid if you have the respective banking license. For example, in Luxembourg, you must not sign a contract if you don't have a license in Luxembourg. In the UK, France, Ukraine, and Uzbekistan, the contract will be considered void if it is in violation of local rules. So you have a significant exposure even in private law, and trust me, your client will be happy with it as long as everything is going well, but as soon as things are turning sour and they consult the lawyer, they may actually bring in all these points to your detriment. the last common type of interaction with your clients across borders, and that is increasingly the case, probably overwhelmingly the case today, is by means of remote communication. So you simply call your client from Singapore, you send them an email to another country, you send them a fax to another country. Do you already enter that jurisdiction or not? Once again, it depends on the jurisdiction. For example, when you are purely looking into promotion in Taiwan, you can generically promote your brand. So you can have the advertisement of your Singapore bank. Don't go into details about what services you provide, but you can run a branding campaign out there, but you cannot present specific services in there. For the Philippines, previously I had mentioned that you cannot do the activities when you are onshore, when you set foot into the Philippines. For example, you cannot accept that brokerage order. Because of the Philippine regime, it is possible to do that by remote means. You can send the account statement by email to your Philippine client. You can accept a brokerage order from your Philippine client through email. You can chat to him on the phone and give investment advice. But it's not only when you promote your services, when you are providing services. It's also about financial products that can go across borders. When you have a financial product, for example, your Luxembourg fund, your Cayman fund, are you actually allowed to sell it in that specific jurisdiction you are looking at? For Singapore, I guess most of us are aware that if you have, for example, a collective investment scheme, you need to get that authorized or licensed, or recognized. If it is a foreign one, if it is your Cayman, your Luxembourg, you need to have it recognized so that you can sell it to your clients. The same thing or similar things will apply to most, if not all, other jurisdictions. You want to sell a Luxembourg fund or a Cayman fund to a Spanish client, well, yes, Spanish regulations apply. With the Luxembourg fund, you are quite lucky because they're both in the EU, and thus they have many common rules and regulations, and there is the passporting. But if it's a Cayman fund, well, you actually need to go through the hoops of getting that properly licensed in Spain. As real life goes, it becomes even more complicated because in most instances, or in many instances, you will actually have a mix of all those different aspects that I have been talking of before. You have your head office, you have your office in Singapore, you have a branch involved abroad, you have a investment advisor, a relationship manager abroad. So to go on to this example, it can be for the Singaporean bank has a branch office in Dubai. So you need to look into Dubai regulations, what you can or cannot do as the branch office in Dubai. Then your relationship manager from the Dubai office actually travels to the UK, possibly to meet the client there. So you need to look into what can he do in the UK without a license. And if he calls a client in Brazil from the UK, you also need to look into Brazilian regulation because your client sits in Brazil. And if you want to sell your Cayman fund to the Brazilian client, you need to make sure that your Cayman fund can actually be sold, is admitted to be sold by your Dubai branch office, and it may be sold to a client in Brazil. So you can have many layers of cross-border regulations kicking in there. The big question all of you are asking on that is, how do we actually deal with it? You can take a very, very simple approach to it. You can simply prohibit it and say we restrict ourselves to working with Singapore clients only. Considering the very beginning when I told you that 77% of assets under management in Singapore are foreign assets, you might actually want to reconsider your business strategy. I don't think it is a viable business model in Singapore, so you can kind of forget about that prohibition. It would also mean that you cannot talk to your Singapore client if he is on vacation to Korea, because that would mean he is now on Korean territory. You can establish a branch or a subsidiary, so at least you will have another jurisdiction where you have a license. As indicated before, that will not cut out all the challenges for you, and on top it is quite a costly exercise to set up branches and subsidiaries, in particular when they are licensed or regulated. Then some countries, for example Spain that I mentioned before, offer cross-border licenses. That means you don't need to have an onshore presence to legally perform certain regulated activities on their territory with their residents, as that specific cross-border license allows you to do. You can apply for that cross-border license, potentially send your Singapore RM over, talk to your Spanish client. You need to look at the specific regulation for that. And if there is no cross-border no cross-border license available, you should seriously consider, if you don't yet have that established, establishing cross-border policies which tell your RMs what they can do in a foreign country with respect to a foreign client. For a specific country, can you call that client? You may consider getting cross-country manuals that explain to you for a specific country, for example, for Thailand, for Indonesia specifically, if you want to travel to Indonesia, what can you do in Indonesia? Can you hand over an account statement? Can you discuss the investment portfolio? Can you hand over your recommended investments list? Can you actually follow up with a phone call once you have returned, or can you not? So it is advisable to have a cross-border policy that covers cross-border activities in general, and on top country manuals for specific countries that you deal with on a quite frequent basis. None of these instances, none of these solutions, as with everything in compliance, will give you 100% security. It simply does not exist. You have to look at your cross-border activities, your policy, the setting up of a branch office. You always have to consider that as a management of your cross-border risks. You will never be able to manage 100% of everything. It is also about how much effort and resources you can dedicate to simply that specific topic. It is not the only compliance issue you have to take care of. You may have clients from 100 countries of this globe. Can you actually have country manuals, and can your RMs possibly know the rules and regulation of all these 100 countries? I don't think so. So you have to find your way how to mitigate the risk to be active in between all those different jurisdictions.